inauguration was on March 4, and we didn't have a president until when?
Till early in the morning on March 2nd. We didn't have a determination
Wow.
until early in the morning on March
That's
2nd.
wow. Okay, so are are these competing documents, the slates actually sent to the US Congress?
They were, yes.
What to do? That's crazy.
So what
Which
to
one
do?
do
That is
exactly?
crazy. And there
Wow.
was no blueprint in the Constitution for how to determine which of those competing electoral votes to count.
Did a faithless elector incident occur in 1968?
In 1968,
And this worked, correct me if I'm wrong, this was an operation for all intents and purposes, worked until January 6, 2021.
correct. And we should talk about the extent to which it worked and didn't work.
Yeah, yeah, yeah.
Ultimately, it worked, right? Congress knew which votes to count in January of 2021, but there were some.
Professor Shorstall, Happy New Year.
Thank you.
It's a pleasure to have you on our program. Thank you for taking the time for this conversation with me.
Thank you for inviting me. I'm glad to be here.
Something important will happen in Congress on January 6, 2025, and hopefully it will not be interrupted like it was on January 6, 2021. So let's talk about it. What's going to happen and why is this important?
What will happen on January 6th is very important and almost always boring and ministerial. And I expect and hope that will be
Oh,
the
don't
case.
say boring. This is exciting to us.
I expect, well, significant, and there's a lot that's really important about why it's structured the way it is and how we've got it. What actually happens that day is
Mm-hmm.
typically not very dramatic. What happens on January 6th
Mm-hmm.
is that Congress counts the electoral votes. So it is the formal process provided for in the 12th Amendment of the Constitution for counting the electoral votes and determining which candidate for president has received a majority of those votes. And once that majority is determined, it is the official end of the process of electing presidents and the final sort of certification or determination of who has been elected. Now,
Um,
if there are the potential circumstances where there is not a majority and then we have a contingent election, we can talk about that. It's
yeah.
only happened twice in American history, but what typically happens is the electoral votes are counted, and when it's done, the president of the Senate declares who has been elected, and that's the final step in the process of electing the president.
Couple of follow-up questions, clarifications. You said they Congress counts the electoral vote. I get that. You didn't say certified. That has already happened by the states in December. Am I correct on that?
Correct. Yeah. So each state certifies the outcome in its own presidential election. And there's a process set out by statute for the form that needs to take when that final certification is transmitted to Congress so that
Mm-hmm.
Congress knows who are the electors that were appointed by each state.
Yeah, yeah.
But what happens at Congress at the joint session on January 6th is the counting of those electoral votes. We often hear kind of colloquially in the media discussion that process is referred to as a certification. What the
Hence my
Constitution
question. Yeah.
what the Constitution refers to in the 12th Amendment and what's happening as a functional matter is the counting, the tallying of those electoral votes.
I see. And just to go back to your comment that what happens on January 6th is boring, um, perhaps the use of the word boring makes sense because it's somewhat a formality. Everyone knows, everyone should know, and you're just counting these votes that everyone kind of knows.
Exactly. So what
Yeah.
happens overwhelmingly over the course of American history, what I expect is going to happen a few days from now, is that there is no drama, there is no decision making, there is no dispute, there is arithmetic.
Yeah.
That's
Yeah.
what the Constitution anticipates. That's what we typically see. That's what I expect we're going to see this year.
I'm going to share three names with you, and you tell me how they relate to January 6th. This is kind of a delicious story here. There's some drama here. Richard Nixon, Al Gore, and Kamala Harris. How do they relate?
So the 12th Amendment, which is what structures this process for
Mhm.
how the presidential electors cast their votes and how those votes are counted, says that the person who opens the certificates containing the electoral votes, the person who typically presides over the joint session, is the president of the Senate. The president of the Senate is usually, not always, but usually the vice president. So Richard Nixon was the vice president in 1961 when he presided over the joint session in which the votes were counted, indicating that he was defeated in the presidential election against John Kennedy. And there was a wrinkle in the counting of those votes, which we can talk more about, where it was straightforward which votes from the state of Hawaii ought to be counted, but there were multiple slates of electoral votes that had been submitted. Um, Al Gore in January of 2001, similarly, was at the end of his term as vice president. So in his role as president of the Senate, he presided over the counting of the electoral votes in the election where he lost to George W. Bush. Of course, there had been lots of drama in that presidential election
That's an understatement. Hanging
before
chatter all
January
day. Yeah.
6th. Very dramatic election, of course, culminating in the Supreme Court's decision. And there were some objections to some of the electoral votes during that joint session. We can also talk about that later. But of course, he presided over that joint session in which the outcome was that he lost his presidential election to George W. Bush. And so similarly, Vice President Harris, in her role as president of the Senate, will
Yeah.
preside over this joint session next week. And the outcome of the tallying of those electoral votes will be that she has lost this presidential election to Donald Trump.
Yeah. Well, was Richard Nixon the first VP to essentially count the votes that confirmed his own loss? Had that happened in history before? I can't think of any.
I don't think that had happened in
Yeah.
history before. Of course, John Adams famously counted the electoral votes when he prevailed in the election of 1796.
Yeah.
But I don't think there had been a previous instance of a vice president presiding over a joint session when he or she had lost the election.
Yeah, I can't think of that either. I read a draft of your paper titled Congress's Power Over the Electoral Count. I learned that quite a bit. It will be published in Vanderbilt Law Review, and I will provide a link in the description for our audience to read it. I think it was a wonderful paper. I want to focus on one point for our audience here. You state, and I'm paraphrasing here, Professor Shorstall, you state that in our country's history, contested elections that take us to the brink are the impulse for changing the electoral vote. So, what were those contested elections?
We've seen this a few times throughout American history, and there are really three key examples where a presidential election has remained disputed up until the joint session, where there has not been an obvious off-ramp,
Wow.
where there has been a significant instability as a result of those disputes, and that in the period that follows, we see reform of the legal structure governing how presidential elections work. And so the three examples I have in mind are the election of 1800, which led to a contingent election in the House that took 36 ballots to resolve, as between Thomas Jefferson and Aaron Burr. As a result of that, we get the 12th Amendment.
Wow, 36 votes in the House.
Correct.
Wow, okay.
which was, and we can talk more about each of these, but
Sure,
that's
sure,
the first
sure, please.
example that I would point to. The second is the disputed Hayes-Tilden election of 1876, in which there were multiple slates of electoral votes from 4 states, and that the process for resolving which votes to count and for determining the winner of that election extended until 2 days before inauguration date. Inauguration date in 1877 was
Wow.
March 4th. That presidential election remained unresolved until March 2nd. As a result of that election, that we get about a decade of effort on improving the legal structure for presidential elections, but in 1888, Congress passes the Electoral Count Act. And then the third example I have in mind is the election of 2020, where, of course, we have the
Yeah.
unprecedented attack on the United States Capitol. We have this manifestation of political violence around the joint session. And as a result of that, 2 years later, in December of 2022, Congress enacted the Electoral Count Reform Act, which again changed the legal architecture, the statutory architecture for how presidential elections work.
Wow. So we got 1800, 1876, and 2020, 3 elections that brought about huge change. This is fascinating. We'll be back after a short break to talk more about elections that took us to the brink and the changes that happened in their aftermaths. We'll be right back. Professor Shorstall, how did the original Constitution of 1788 deal with counting and certifying the electoral vote? As you can tell, I'm going to the beginning.
Sure. So in many ways, the structure for counting electoral votes, the structure of the Electoral College was quite similar to the structure that we currently have.
Hmm.
Um, although after the election of 1800, it changed in a couple important ways. But in the original Constitution, the states appoint presidential electors in a manner that they determine. Congress
You
has the
mean the
authority.
states in a manner that states determine for their
Correct.
own? Okay.
Correct. And so each state can decide the world we live in today, every state appoints their electors based on the popular vote. But that was not true in 1789. And there was in the earliest years of the country, there was a variety of approaches. In some states,
Hmm.
legislatures directly appointed electors, and others they were elected through popular vote. But so the original Constitution said states get to appoint electors.
Mm-hmm.
Congress has the power to set the date on which they do that, that those electors then gather on a uniform date determined by Congress in their own states, and that they cast, under the original Constitution, that each of those electors casts 2 votes for president. One of those votes has to be for someone who is not an inhabitant of the same state as the elector. So the idea was there was a concern that electors would be inclined to vote for the favorite sons within their
Yeah.
states, the
Yeah.
people who
Yeah.
were the dominant political figures in their states, but this ensured that they would vote for at least one person who would be understood to be a national figure. So the electors the electors cast 2 votes. The certificates of those votes were then transmitted to the seat of government, and specifically to the president of the Senate. The original Constitution said the president of the Senate then opens the votes in the presence of both houses of Congress. The votes would then be counted. And the person who has under the original Constitution, who has the largest share of votes, assuming it's a majority, would become president. The person who was the runner-up would become vice president. If under the original Constitution, 2 candidates had both received a majority of the total number of electors, but they had tied, this was possible under the original structure because, remember, each elector cast 2 votes. Then the House of Representatives would choose between them in a contingent election. Or if there was no candidate who had received a majority of the whole number of electors, then the top 5 candidates would be uh, um, uh, in a contingent election in the House. The House would choose among the top 5 candidates to determine who would be president.
Professor Schorstol, you had me at casting 2 votes, kind of like from our perspective, kind of a weird system, and it actually doesn't take long for potential issues of this system to come to a head, which takes us to the 1800 election, correct?
Exactly. And so one of the things that the framers just didn't anticipate in that original structure was the kind of party system that's familiar to us, the party ticketing system that's familiar to us. It's very natural for us to think of a ticket including a presidential and a vice presidential candidate who are kind of traveling together and casting a vote for the 2 of them. That wasn't what was envisioned by the framers in the original structure. They envisioned the members of the Electoral College deliberating with the other electors in their states, and again, with the notion that many of them might vote for one candidate from their own state and then someone who was seen as a national figure. And this would all kind of come out in the counting where someone would be elected president because they would receive the greatest number of votes, and then the second place runner-up would be the vice president. And that
doesn't that sound a bit naive from our perspective now?
It certainly sounds intensely unfamiliar, and it collided
Exactly,
very quickly
yeah.
with the emergence of the party system. And so what happened in 1800 is Thomas Jefferson and Aaron Burr were both Democratic Republicans. And the understanding was that Thomas Jefferson was that party's choice to be president, and Aaron Burr was that party's choice to be vice president. But what happened is that all of the electors, all of the Republican electors, cast their 2 votes for those 2 guys. And so they tied. In contrast, the Federalists were a little bit more savvy. They had coordinated among their electors to cast essentially one throwaway vote to ensure that John Adams maintained an advantage over his co-federalist. But the Republicans cast an equal number of votes for Jefferson and for Burr. And as a result, under the provisions of the original Constitution, Article 2, there was a tie between 2 candidates who had each received a majority of the electors, a majority of votes based on the number of electors, but had tied. And so the mechanism for dealing with a tie was for the House to choose between those top 2 vote getters in a contingent election. The problem is that this became an intensely bitter fight when the contingent election reached the House of Representatives. Part of the reason for that is that the House of Representatives at that time was still controlled by the Federalists, and they were not looking to do the Republicans any favors. And so when a contingent election happens, this was true under the original Constitution, it's still true. The votes are cast by states. So it's not that each member of the House gets an individual vote, but that each state voting as a delegation gets a vote. And so the Constitution requires that to win a contingent election, a candidate needs a majority of the votes cast among those state delegates. And Congress, the House was at an impasse. Neither of those candidates received a majority for the first 35 votes that were conducted within the House. It took 36 ballots before Thomas Jefferson was able to obtain a majority of the votes. And this dispute really took the country to the brink. There was a real concern. There was no off-ramp. It was not clear what would happen if a winner was not chosen by inauguration day. There was a real risk of political violence at a significant level if the House was not able to reach a resolution that was seen as legitimate. And so this dispute following the 1800 election was seen as revealing a real shortcoming, kind of structural deficit in that original constitutional structure. That structure had a blind spot. It didn't anticipate members of the same political party running jointly, which would predictably, right, once the party system emerged, it's predictable that there's this risk of what we would now think of as ticket mates receiving
Yeah.
an equal share of the votes. And so there was an understanding, and particularly among Jefferson's Republicans, there was an understanding that that system needed to change.
Yeah. And another wrinkle, which is a little bit off topic, but it's historically interesting, is that Jefferson was actually Adams's VP, and both of them are running against each other. And all of this weirdness and crises, as you said, real potential for political violence, takes us to the 12th Amendment. Is that correct?
Exactly.
Yeah, please do share with
And
us.
so in 1804, Congress passes, and several months later, the state legislatures ratify the 12th Amendment. The 12th Amendment maintains much of that structure that I described a few minutes ago from Article 2 of the Constitution. As with so it does nothing to change the role that states have in appointing electors.
Okay.
It maintains the idea that the electors then meet on a uniform date. This is a date that's set by Congress. They meet on a uniform date in their own states, and they cast their ballots for president and vice president. The key difference to address this problem of co-partisan ties, the key difference is that each elector, instead of casting 2 votes for president, where the winner becomes president, the runner-up becomes vice president, casts 1 vote for president and then a distinct vote for vice president. So that's the key difference, the main innovation that the 12th Amendment introduces. It also makes some changes in the ways that contingent elections work. Among other things, it provides for the possibility that you might need a contingent election to choose the vice president. Under the original Constitution, you wouldn't have needed to do that. Now the Senate would hold a contingent election if necessary to choose a vice president. Make some other changes in the structure of how contingent elections work. But the key thing it does is to bifurcate the balloting between the presidential ballot and the vice presidential ballot.
Which is what we have today, which is what we're familiar with.
Exactly.
Okay, that sounds simple enough, digestible enough for us to understand. But then we fast forward in history, we have the Civil War. It ends in 1865. Shortly after, I think within a month, President Lincoln is assassinated. His VP, Andrew Johnson, becomes president. He becomes the first president who's impeached. Then the Union hero, Ulysses Grant, becomes president for 2 terms, which takes us to the election of 1876. So we have the 12th Amendment. It worked. What goes wrong here?
So the 12th Amendment did an excellent job of solving the problem, that the narrow problem that it was aimed at solving, which was this problem of facilitating party tickets. What it didn't do, and what nothing in the constitutional structure directly addressed, is the problem of what happens if you have multiple slates of putative electoral votes from a single state. And so the crisis following the 1876 election between the Republican Rutherford Hayes and the Democrat Samuel Tilden is that you have 4 states where there are dueling slates of electors. So the 4 states are Florida, South Carolina, Louisiana, and Oregon. And in order to win the election, Hayes needs all of the votes from all 4 of those states. If any of the disputed votes were counted for Tilden, Tilden would win. And in each of those states, there was a plausible argument for counting one slate or the other. And we can get into how each of the different states broke out. It looked different in each of those states. But for example, in Florida, you have the Republican governor certifying the electors in favor of Hayes before the electoral votes are cast. And you also have the Democratic Attorney General of the state purporting to certify a Tilden slate of electors. That slate also met and cast their ballots on the date designated by Congress. Subsequent to the Electoral College meeting, when a new governor, Democratic governor, takes office in January of 1877, that governor then issues a new certificate purporting to certify the appointment of the Democratic electors. So you have these 2 slates of electors. You have competing documents purporting to legitimize them.
Wait, Professor Schwarzschild, are these competing documents, the slates, actually sent to the U.S. Congress?
They were, yes.
What to do? That's crazy.
So what to do? That is crazy. And
wow.
There was no blueprint in the Constitution for how to determine which of those competing electoral votes to count. As you said a minute ago, we are only about a dozen years removed from the Civil War. Here again, there's a real risk of political violence if this, in the absence of a resolution that's seen as legitimate. And we have deeply entrenched partisans on each side, the Republicans in favor of Hayes, the Democrats in favor of Tilden. And
Democrats, more or less, just for our audience, still kind of represent the South. The South that was defeated just 11 years ago in the Civil War. I see.
Exactly.
Okay.
And so Congress realizes that it needs a solution, and it enacts a statute called the Electoral Commission Act. And the idea behind—
Wait, Professor Schwarzschild, you started an exciting story, you didn't end it. What happens to the 1876 election?
So I'm going to tell you this.
I see.
So the Electoral Commission Act, right, not to be confused with the Electoral Count Act, which we get about a decade later.
Okay.
Right. So in December of 1876, Congress passes the Electoral Commission Act.
Okay.
And the idea with the Electoral Commission Act is we need a way to solve this impossible problem. The Constitution doesn't give us a blueprint. We need a way to to adjudicate these disputes and determine for these 4 contested states which electoral votes we're going to count.
Okay.
And so the Electoral Commission Act creates this commission, 15-member commission, and says the commission is going to determine, for any state where there are multiple slates of electors, the commission will determine which is the legitimate slate, and then Congress will count those votes unless the 2 houses of Congress concurrently vote to reject the commission's conclusion. And since we have a Democratic-Republican split across the houses, that's essentially impossible or exceedingly unlikely.
Okay.
And so the idea is that the commission's determination will almost certainly be the determination about which votes get counted. And so so then we have this immediate problem. How do you engineer a commission?
Or the members.
Decisions would be seen as legitimate, right? Who gets to decide? And so the solution, the maybe kind of elegant solution, is that each chamber of Congress would get to appoint 5 members, and then there would be 5 members from the US Supreme Court. And so, predictably, the Democratic House appointed 5 Democrats, the Republican Senate appointed 5 Republicans. So far we've got, right, what
Yeah.
we'd anticipate is loggerheads.
Yeah, exactly. 5-5.
For 4 of the Supreme Court justices, the statute designated the justices who would be appointed, not by name, but by the circuits, the judicial
By the
circuit that
circuit.
they were
Okay.
associated with. And that, again, was understood to have a 2-2 split. 2
Like
justices who
if
would be
geographically from the South, they would go for
ex-
example, Tilden. Yeah, I see.
exactly. And the statute said that those 4 justices would then get to choose a 5th justice, which is to say a 15th and final member. And just to add to the drama of this, the
Yeah.
understanding, everyone's shared understanding when the Electoral Commission Act was passed, is that the 5th justice would be Justice Davis, was seen as the least partisan of the justices, the justice most likely to be perceived as nonpartisan and to therefore be a fulcrum for this commission's decision making.
That sounds good.
Sounds great. Justice Davis was so popular that the Illinois legislature in this intervening period appointed him to be one of their senators. And so he was no longer, he left the Supreme Court and was
Wow.
no longer eligible, no longer able to be the 15th member of the commission. So the 4 justices who had been appointed appointed the justice who was seen as, among the remaining choices, the most tolerably nonpartisan of the remaining choices, and they chose Justice Bradley. Justice Bradley was a Republican, but was seen as relatively nonpartisan. And so the commission, splits in predictable ways. So the commission for each of the contested states splits 8-7, with all 7 of the Democrats reaching the determination that the Tilden electors in the 4 contested states were properly appointed, and all 7 of the obvious Republicans plus Justice Bradley, right? So 8 of the 15 commission members determining that the Hayes electors were the ones whose votes should be counted. And so Justice Bradley writes an opinion on behalf of the commission, setting out his legal analysis and explaining why for each of the 4 states the Hayes electors had been properly appointed. This goes back to Congress. There are some last-minute efforts by some Democrats in the House to derail this resolution, but Congress ultimately holds steady. They count the votes, the Hayes votes, consistent with the ruling of the commission, and Rutherford Hayes becomes president. And what this reveals to Congress, right, this statute that I described a moment ago, the Electoral Commission Act, this was a good for one election only solution. It didn't create a permanent structure. It didn't create a standing body that would adjudicate future disputes. And so there was an understanding that some new statutory framework was necessary so that in the future, if there were dueling slates of electors, there would be a framework for determining which ones to count. And that's how we get, in 1887, the enactment of the Electoral Count Act.
Which when you say Electoral Count Act, which I mistook earlier with the Electoral Commission Act, and I got
There's
all
two
excited.
ECAs. It's an
I
easy
I thought you
mistake
were
to make.
jumping
But
ahead,
yes,
skipping the exciting story here. Just one thing that I recall from my own readings of this election in 1876, that some people call it almost a Civil War 2.0, almost went to there, is that inauguration was on March 4, and we didn't have a president until when?
till early in the morning on March 2nd. We didn't have a determination
Wow.
until early in the morning on March
That's
2nd.
wow. Okay, so wow. So 2 days before inauguration, which takes us to the other ECA, Electoral Count Act of 1887,
Correct.
11 years, 10 years after this inauguration.
Exactly.
What is this? What happens?
So the main innovation that the ECA introduces is a decision-making framework. So it sets up the core of the ECA, its main provision, sets up a framework to guide Congress and says essentially, when the president of the Senate opens the certificates of the votes from the electors and the votes are read to the members of Congress,
Mhm.
if there is only one vote, only one slate of votes, then Congress counts that slate of votes unless the two houses concurrently, unless there's a valid objection, and then the two houses concurrently vote to reject it. But then it sets out a framework, a kind of cascading set of decision rules, and says, well, okay, if there's multiple slates of electors, how do you determine which one to count? And it provides a set of answers that we might think of as kind of forensic or procedural. It doesn't say to Congress, count the ones reflecting, the real winner, the person who really won the most votes in each state. It didn't invite Congress to go and look underneath the results in each state. Instead, it said to Congress, the states will have a certain protocol for certifying their elections. And if you've got multiple slates of electors, you count the ones whose electors were appointed consistent with this protocol that we've outlined. And that, again, that protocol, it kind of says, it says the executive of each state will issue a certificate of ascertainment. It will announce in that certificate who the electors were that were appointed. It sets up procedure, right? It doesn't go to substance.
Yeah.
So the Electoral Count Act says if you've got only one slate, you count the one slate. If you've got multiple slates and one of them is issued consistent with these procedures that we've set out, you count that slate. If you've got multiple slates that purport to be consistent with that procedure, you count the one where the certificate of ascertainment has the governor's signature. And so what it's doing is giving Congress a framework, a basis to say, if we have a problem that looks like the problem of 1876 and 1877, where we have these dueling slates of electors, we've got some rules of the road for determining which ones to count.
And okay, this sounds good. It's detailed. I get it that they're not looking at the breadth, sort of the substance of the election. They're really, it's almost like administrative. This is a procedure. One, if one doesn't work, go to two, three, and so
Exactly.
forth and on. This is in 1877. And this,
1887.
I'm sorry, yes, thank you for correcting me, 1887. And this worked, correct me if I'm wrong, this was an operation for all intents and purposes, worked until January 6, 2021.
Correct. And we should talk about the extent to which it worked and didn't work.
Yeah, yeah, yeah.
Ultimately, it worked, right? Congress knew which votes to count. in January of 2021. But there were some um, issues with the existing legal framework that were understood as having been contributing causes to the violence on January 6th. We should talk about that. But yes, to
Definitely.
answer your question, that statutory framework remained in effect for every presidential election, starting with the election of 1888 and through the election of 2020. And this election that we've just completed is the first one to take place under a modified statutory regime. And so the joint session that will take place on January 6th will be the first time that that new statutory regime has been implemented.
And we're going to get to that, to examine the ECA, the Electoral Count Act that was passed in 1887 and was in operation for, I don't know, 134, 135 years,
Yeah.
effective operation. I want to ask this question, and I'm basing this question based on something you said. I think it was in segment number 1. You were talking about Richard Nixon in the 1961 electoral count on January 6th. Did you say there were multiple slates? Did I hear you correctly? If
There
that's the case,
were.
oh, okay.
There were. So there wasn't the kind of dispute that we saw following the 1876 election, but there were multiple slates of electors. So this all comes down to the state of Hawaii and Hawaii's 3 electoral votes. And I say that there was no dispute in part because whatever happened with Hawaii's votes was not going to determine the outcome of the election. Is the first observation. The second observation is that it was pretty clear to all good faith observers, including Richard Nixon, what the right answer was in Hawaii. So let me tell you what happened, and it's an interesting historical moment.
Yeah.
An interesting precedent, just in terms of ensuring that the appropriate votes are counted, but not the kind of post-election dispute that puts pressure on the legal system. So what happened in 1960 is that following the initial counting of Hawaii's popular vote, Richard Nixon was ahead. He had a small lead. And so the governor of Hawaii issued a certificate of ascertainment appointing the Nixon electors. However, it was a small enough lead that the Democratic electors and the Democratic Party of Hawaii filed a lawsuit seeking a recount pursuant to Hawaii law. And so that recount was pending. It had not yet been resolved on the date that the electors were scheduled to meet. And so the Nixon electors, who at that point had a certificate of ascertainment signed by the governor, they met at the state capitol on the appointed day and they cast their votes for Nixon. But the Kennedy electors, anticipating that this recount might come out in Kennedy's favor, that they might, subsequent to the recount, receive a certificate of ascertainment, and knowing that there is a uniform date for the electors to cast their ballots, the Constitution requires that, they also showed up at the state capitol and cast their electoral votes for the Kennedy ticket. So you have first a certificate of ascertainment appointing the Nixon electors that was transmitted to Congress along with the Nixon votes in December of 1960. In early January, when the Hawaii State Court rules in favor of the Kennedy electors, it issues a decision stating that Kennedy had won in Hawaii, and the governor of Hawaii at that point issued. In December had been an acting governor, the newly elected governor, then so a different person, but the new governor issued a certificate of ascertainment appointing the Kennedy electors. We have 2 different governors, but not partisan intrigue, right? We have this thing that's taken place, right? The state court has made this determination on behalf of the Kennedy electors. So the the governor issues a new certificate of ascertainment. That's also transmitted to Congress. And so there's actually three packages that go to Congress. The first is the original Kennedy certificate with the Kennedy votes. The second is the Hawaii State Court decision along with the Kennedy votes. And then the third is the governor's certificate of ascertainment appointing the Kennedy electors. So these three sets of documents show up at Congress. They're provided to Vice President Nixon. Vice President Nixon doesn't activate the objection procedures that the Electoral Count Act had created. Instead, he says that his conclusion is that the legally valid electors are the Kennedy electors appointed pursuant to the governor's certificate of ascertainment. There's no objection to that determination. And in the absence of any determination, those are the votes that were counted in January 1961.
But Nixon could have taken advantage of that situation, and he didn't.
He could have. And so, it's a question of what good would it have done him?
Yeah.
I'll note if you read Nixon's floor statement, I'll note two things. One is that he makes a point of saying, without the intent of setting a precedent, he's making the determination that the Kennedy votes are the appropriate ones to be counted. Whether that statement gives this moment any more or less precedential value, who knows? But he also, at the end, acknowledges the importance for the country of ensuring that the appropriate electoral votes are counted and that the appropriate winner is selected. And the answer in that election was John Kennedy. Again, that would have been true with or without the Hawaii votes, but Kennedy won the Hawaii votes, and Nixon acknowledged that and acknowledged in his floor statement the importance of ensuring that the appropriate electoral votes were counted.
Yeah, I've actually listened to Nixon's statement at the end of the counting of electoral votes in 1961. He gets a standing ovation, a long one from both parties. That's fascinating. A small point, Professor Schulzthal. If I have this wrong, we can just move on. But I'm just wondering, did a faithless elector incident occur in 1968?
In 1968, yes.
Yeah. What is that something that worth it for us to discuss? It's interesting. I've never heard that before.
Yeah. So following the 1968 election, Richard Nixon wins this time. One of the Nixon electors from South Carolina casts his electoral vote for George Wallace.
Oh,
so here again, right? Nixon has won the election with or without this rogue vote.
Yeah.
But there's an objection made according to the ECA's objection procedures, and actually a long debate about whether that vote should be counted or whether it should be excluded, and a long debate about whether, on one hand, a vote that is cast contrary to what the voters of South Carolina anticipated the Republican electors were going to do, whether that would be a vote that would be not regularly given, which is the standard that the ECA put in place for the electoral votes that Congress might, in some circumstances, not count. So just as a quick detour, right? The Electoral Count Act contemplates objections to electoral votes that were not regularly given. And so that's conventionally understood, although there's not a lot of clear legal authority on this. It's conventionally understood to encompass some easy cases, right? An electoral vote cast for someone who's not eligible to be president, say because they're under 35 or they're not a U.S. citizen. an electoral vote cast as a result of bribery or coercion. So there's a debate. There's some members of Congress who say, the voters of South Carolina who voted for Richard Nixon expected that vote, if Nixon won in South Carolina, to translate into electoral votes for Nixon. And a faithless elector that defies the understanding of the voters in that way has cast a vote that's not regularly given, right? So some members of Congress making arguments along those lines, others saying Article 2 contemplates that the states get to determine the manner for appointing their electors, and then it lets the electors cast the votes that they want to cast. And we have no basis, if someone has been validly appointed and their electoral vote is not otherwise invalid, we have no basis as Congress to refuse to count that vote. Ultimately, Congress counts the faithless electors vote in the joint session in 1969, but again, without any impact on the outcome of the election.
What's notable about these two examples that we discussed, 1961 and again 1961, and then again in 1969, both relating to Nixon, is that the issues were not material to the outcome of the election. Had it been, like, for example, I don't know, 20 faithless electors, or instead of a state of Hawaii, it was, pardon me, New York State or Texas or something, we would have a whole different conversation now. Which brings me to 2020 and January 6, 2021. In your paper, as well as other sources, my readings, I've come across this statement that it is widely seen, it is widely accepted that ECA's deficiencies contributed to the attack in January 6, 2021 on Congress.
Yeah, so let me say a little bit about that. There's two ways in which I think that is true and was understood by the Congress when it enacted reform, the Electoral Count Reform Act, to be true. And let me say a little bit about each one. The first is directly related to the ECA. The second way in which the ECA was seen as a contributing cause might be sort of a misnomer where there were some issues with the statutory framework that were not actually enacted as part of the Electoral Count Act. And so I'll say something about each of those. So I said earlier that the main thing the ECA attempted to do was set out a decision-making framework for what to do in the event of dueling slates of electors.
Yeah, kind of the procedure 1, 2, 3. If this doesn't work, go ahead.
Exactly. Yeah. The provision of the statute that set out that set of decision-making rules was famously dense, confusing, in some ways ambiguous, or arguably ambiguous. There's almost a parlor game in a lot of the literature written about the Electoral Count Act to come up with the right term of disparagement to describe how badly drafted it is. It's described in the literature as turgid, as almost unintelligible. It's described by one law professor as a monstrosity. I sometimes say to my students here that this is an example, a vivid example of an area where poor draftsmanship might take the country to the brink.
Yes.
And so why is that relevant? In a certain way, there was really no question. There was no legitimate question under the ECA about which electoral votes should be counted at the joint session in 2021.
Yeah.
It was clear in every state which set of electors had been appointed pursuant to a valid certificate of ascertainment. All of the legal challenges that might have questioned or upended those appointments were rejected. So I want to be clear that there was no actual ambiguity about what the ECA required in 2021. Where I think the problems with the ECA played a role, and part of the reason I think Congress was motivated to take action is that the fact that the decision-making framework was dense, confusing, in some particulars, arguably ambiguous, fueled a sense that the joint session was an opportunity to make a last stand, that there was play in the joints, that there was an opportunity for contestation. So again, I want to be really clear and kind of distinguishing between the work that did atmospherically from any conclusion about any legal conclusion.
Yeah.
There was no legal ambiguity, but it contributed, I think, to a political sense that the joint session was potentially a free-for-all. And so I think that's one way in which the ECA was a contributing cause.
Mm-hmm.
The second extremely important thing that the ECRA addressed was a provision.
ECRA is what we're going to talk about later. That happens.
The reform bill in 2022.
Yeah. Okay. Go ahead, please.
A problem that existed before 2020, but became manifest in 2020 was a result of a statute enacted before the ECA. So there's a statute that Congress enacted in 1845, where it sets a uniform date for states to choose their electors, which as a practical matter in the modern world means a uniform date for holding elections. But it had a provision that said that if a state fails to choose its electors on the appointed day, that it could then appoint electors in a manner determined by the legislature. And in the context of 1845, it was clear what Congress was trying to do. What Congress was trying to do was to provide for states that held runoff elections because their state laws required that the winner in a presidential election win a majority of the state's popular votes. And if you had more than two candidates running and you didn't always have a majority winner.
Look at a plurality.
You had a plurality. This provision allowed for states to hold runoffs. That's the historical context. Of course, that's not what the language of the statute said. The language of the statute was arguably broader. It was not clear what what it means for a state to fail to make a choice on election day. And so that language was seen as a legal hook for people who were trying to convince state legislatures in the aftermath of the 2020 election, state legislatures in states where Biden had won, but there were Republican majorities in the legislature, that they should somehow determine that their state had failed to choose electors on election day on the basis, these people argued on the basis of a conclusion that there had been widespread fraud, right? An unfounded conclusion, predicate, but invoke the specter of widespread fraud, say that the state had failed to choose, and then have the legislature directly appoint an alternative slate of electors. Now, there were no states, no legislatures took up that invitation, but that statutory language at least arguably could have supported a legislature doing that. So this, we'll talk in a moment about the ECRA, but if we're thinking about the issues in the statutory framework going into 2020 and running through 2020 that were seen as combustible, those were the two issues that I think Congress concluded it really needed to address.
Wow. To dumb it down, the devil's in the details, right?
Indeed. Indeed.
Professor Shortstall, I want to get into the ECRA that was enacted just a couple of years ago during President Biden's administrations. But there's one thing that keeps on sort of bugging me. I want to make sure I ask this question. we talked about the 1800 election and the 1876 election, which took us to the brink, and major changes came to our election system, electoral college. But in 1933, we had the 20th Amendment. And that came after a long slate of uncontested elections. Nothing had taken us to the brink. Well, there was a prohibition, and that's a whole different story. But what is the 20th Amendment, and how, how did that change? If you can briefly tell us about that,
Yeah,
please.
the 20th Amendment did a couple important things. And it is, you're right, it's a slow burn reform process,
Yeah.
accelerated at the very end by the Depression. And I'll say more in a moment about the role that played.
Hmm.
Um, the 20th Amendment addressed a handful of longstanding problems. The first and the most central one, just sort of a quirk in the calendar for presidential inaugurations and for new sessions of Congress starting that was embedded in the original Constitution, where under the original Constitution, um, you had March 4th in the year following an election as the date where a new Congress begins. And if it's a presidential cycle, the date on which the president is inaugurated. This created two kind of anomalies. The first is that you had, following federal elections, you had a long lame duck period because the new Congress, one other fact about the original Constitution to mention is that um, although the new Congress would begin on March 4th, Article 1 of the Constitution said that the Congress begins its session in December. And what
Oh.
that means is if you have an election in November, the old Congress ends its term, right? Any members of Congress who've been voted out or retired, right? Their term in office ends on March 4th. But the new Congress didn't actually begin its next session until the following December, which is to say 13 months after the last federal election had taken place. So what you had was, on one hand, this
Oh.
long lame duck session, about 4 months of a Congress, many of whose members may have been voted out, remaining in power, and then the new Congress that had just been freshly elected, not coming in and exercising power until 13 months later. This is relevant to presidential elections because it meant that for purposes of overseeing the joint session, and critically for purposes of any contingent election that might happen, you had the old Congress, the lame duck Congress, continuing in power during that interregnum period before the presidential inauguration. And remember, this was one of the dynamics in 1800, right? We talked earlier about how in that contingent election, the Federalists who had just been voted out of office in the election of 1800 remained in power in the House of Representatives and used that power to jam up the works. They weren't trying to
Yeah.
do favors for the Republicans. And so the 20th Amendment was aimed at addressing those, what I would just call quirks in the calendar,
Yeah.
right? Those were seen as problematic because, number one, again, you have this long lame duck session. The long lame duck session was partly raised a concern about the prospect of corruption, right? This notion that those members of Congress wielding power for 4 months might be tempted either by um, offers of employment out in the world or sometimes offers of employment in presidential administrations. So that was a concern. The inefficacy of the new Congress not beginning its session for 13 months was seen as a problem, and having the old Congress, the lame duck Congress, oversee the joint session and potentially contingent election was seen
It's
as a
just really
problem.
weird. People that have been potentially voted out, booted out, get to decide. I mean, count the electoral votes for a person that may be of the opposing party.
Yeah, count electoral, right. So again, so typically, right, the joint session is not going to be a lot of deciding, it's just going to be counting.
Yeah.
But if you have a dispute
Yeah.
at that point, under the terms of the Electoral Count Act, if you have a dispute, right, you have the lame duck members of Congress as the ones who are still there. If you have a contingent election, then the members of the House in a contingent presidential election, the Senate in a contingent vice presidential election, then they are making decisions. They're not just counting votes, right? They're voting themselves. And so the 20th Amendment um, puts in place what is now the familiar for all of us calendar for the passage of power in the federal government, right? So the 20th Amendment says that the new Congress begins and its first session starts on January 3rd, following an election year, and that the presidential inauguration takes place on January 20th.
I see. Did the old system before the 20th Amendment also mean that the new coming Congress was not in session between March and December, meaning that there was no
Exactly.
Congress?
Exactly. You could
Wow.
you could have a situation where the president convened a special session during that interim period, and that happened occasionally, but rarely. But exactly, you just have this quirk where Congress was closed for business
Oh,
during a
wow.
significant period of time. And again, where you then have this gap between the
What?
members of Congress who are selected and when they actually get to start
Yeah.
doing their business.
Stay with us because we'll be back to talk about this January 6th. And Professor Schwarztal will tell us what's different about this January 6th, 2025. We'll be right back. Professor Schwarztal, what is different about this January 6th, 2025?
So following the 2020 election, Congress enacts the Electoral Count Reform Act.
That's the
And
ECRA you were referring to, right?
the ECRA,
Okay.
indeed. And here I'll just mention the House's January 6th committee, when it issued its final report after its investigation. That report included 11 recommendations, kind of future-looking recommendations to avoid recurrence of the kind of violence that we saw on January 6, 2021. Its top recommendation, right, reform the ECA. And so Congress then acts on that. Congress, in a bipartisan fashion, in December of 2022, passes, and President Biden then signs the Electoral Count Reform Act. And so this is the first presidential election cycle where it's in place. So what's different? Well, one thing that's different is that there is no available argument that state legislatures had any power following election day to just unilaterally appoint electors, right? So this is not a thing that I will say, one thing we don't need to worry about this January 6th or any other January 6th is a question about the legitimacy of electors appointed subsequent to election day by a state legislature, in the way that there may have been a real question, a really hard legal question under the 1845 statute that we talked about a few minutes ago, if the legislature tried to do that. Congress has taken that off the table in the ECRA.
Okay, that's good.
The other thing that the other core thing that the ECRA does is to ensure as much clarity as possible in advance of January 6th about which slates of electors have been appointed, and then additional clarity about how to manage objections to electors on January 6th. So first, at the beginning of our conversation, I described January 6th as this January 6th is likely to be boring. And I want to double down on that. You want January 6th to be as boring as possible. You want it to be C-SPAN's, snoozer in terms of ratings, because you want it to be arithmetic.
Yeah.
You don't want there to be any question. You want to have a framework in place in case there is a question or a dispute. You want clarity about how to adjudicate those disputes, but you want to minimize those disputes going into January 6th. That should be one of the core objectives. And so that's one of the things the ECRA tries to do. It does that by clarifying the way that states need to issue certificates of ascertainment. It does that by clarifying the role for judicial review if there's any question about which slate of electors a state, pursuant to its own laws, is appointing. So those judicial review procedures, those the new judicial review procedures created by the ECRA didn't come into play this year. There were no disputes about any state. There were no disputes about which slates of electors any state should be appointing or whether a state had issued its certificate of ascertainment under the required deadlines. But one of the things that the new statute does is create a framework for trying to resolve with certainty and clarity any of those disputes well before January 6th.
Any other ways that the ECRA helps smoothen, sort of wrinkle out?
Yeah, and so the other thing is it replaces the statutory framework that, as we talked about earlier, the people who study this love to disparage as turgid, unintelligible, right? Confusing, ambiguous. It streamlines those procedures. It makes crystal clear that if there are electoral votes cast by electors who are appointed pursuant to appointed by their state's governor in the way that the statute requires, right? So I told you a moment ago that one of the things the ECRA does is make more clear what has to happen in December following an election year, like well before January 6th, and it sets out the procedures and the kind of pedigree that the states need to issue. The ECRA makes crystal clear that if an electoral vote is cast by an elector appointed that way, in the way that the statute requires, that those votes have to be counted so long as they are regularly given. So we still have this phrase from the ECA, regularly given, which there's, I think, a relatively clear understanding among election lawyers and people who think about the set of issues about what that encompasses. But critically, what it describes, right, votes that are regularly given, is the question about whether elector votes are regularly given is a question about, once that elector who has been validly appointed casts his or her electoral vote, is there any legal deficiency with it? And so here again, those might be things like an electoral vote cast for someone who's constitutionally ineligible, an electoral vote cast as a result of a bribe or coercion. But it is emphatically not an invitation to revisit what happened in a state's election. It's not an invitation to say
it closes that door.
It closes that door. It's not an invitation to say, did this state have a problem with voter fraud or with voter suppression? It's an inquiry that is focused on the actual casting of the electoral votes by the electors. So the ECRA says we're going to make it really clear for Congress to know whether the electors are the ones that were validly appointed. To be a validly appointed elector means to have been appointed in a way consistent with what the ECRA requires. And then once we know who those electors are, the ECRA says we're going to count their votes unless they were not regularly given.
Before we move on from the ECRA, I have two follow-on questions, points to make. One is, if you recall the January 6th, 2021 event, it became an event, talk about not being boring. And we heard this objection where senators or members of Congress, it wasn't just senators, let me correct myself, could object to a certain vote. The ECRA, I'm going back to your paper, I think, also changes how you can object. It's not just one member of Congress, right?
Exactly. Yeah. So
Yeah.
it elevates the objection threshold. So under the ECA, if Congress meeting in joint session, we have the president of the Senate opening the certificates. We have members of Congress who are appointed as tellers, right?
Yeah.
Essentially the people who do the actual tallying. They announce the vote. Um, and you go down the list and count the votes unless there's an objection. The ECA said to have an objection, a valid objection, you needed um, uh, an objection joined by one member of each chamber, one member of the House of Representatives, one senator. And then if you had an objection that met that quite low threshold, then the two houses would separate
Well,
and pursuant to the terms of the ECA, they would spend up to 2 hours debating whether to count the relevant slate of electors. The ECRA maintains that basic structure. You go through and you count the votes unless there's a valid objection. Given a valid objection, the houses separate and debate for a limited amount of time. But under the ECRA, it increases the threshold and says to have a valid objection, you need to have 1/5 of the members of each body
oh wow, that's a
join the
significant
objection.
change.
So it reduces the risk that the counting process is short-circuited by frivolous objections.
Yeah, yeah, I see. Um, you know, two members of Congress can't collude together and just, throw a wrench
Exactly.
into the system.
And in 2020, right? I mean, there were no, of the states that did generate what were under the ECA valid objections. None of them attracted the support of 20 senators, right? So had that rule been in place in 2021, none of the objections would have resulted in the houses separating to debate the objections. Again, under
Yeah,
the ECA, the houses, both houses rejected those objections. They made the
yeah.
legally appropriate determination to count the valid electoral votes. But to the extent that frivolous objections create the kind of opportunity for seeing the joint session, as we talked about earlier, as kind of a last stand, as an opportunity, as a free-for-all, as an opportunity
Yeah.
to raise whatever questions you want to raise, it reduces that risk.
I told you I had two follow-on points questions about the ECRA. I know that this is the second one. I know you're a legal scholar. I'm about to ask you something about the news. January 6th, it's good. It has to be boring. That's a good thing. Boring is good here. But the news about how the ECA changed into the ECRA, the new uh, method of counting electoral votes and all of that, you would think that would be huge news after January 6, 2021. Why do you think it wasn't really in the news all that much?
There were a combination of factors. I mean, one of them probably is the boringness factor, right? I mean, your audience, I know, is going to be with us on wanting to know the details, the ins and outs of the
Yeah, yeah, yeah,
decision-making
yeah.
framework in the ECA versus the ECRA, but it's a technical area. Now, of course, there are technical areas of law that can become intensely politicized,
Mhm.
but the boringness factor probably provided a little bit of probably reduced the spotlight a little bit. I think that there was an understanding among a bipartisan group in Congress that um, number one, it really was important to revise the statutory framework, that the issues that you and I talked about earlier were longstanding problems with the ECA that really needed to be revisited, but that crucially, there was no obvious partisan advantage
Yeah,
to enacting the reforms that you and I just talked about. Reforms that are important. I think it's a big deal. It's important that the ECRA was passed. They're important, but they are also, there's no radical change in anything about how the process for counting electoral votes works. And in many ways, like the basic structure, the idea of the ECA, right? Defer to states, set up some procedural or forensic standards for what the states need to do, try to clearly connect those procedural standards to the counting rules that apply in Congress.
hmm
That's the intellectual framework behind the ECA, and it's the same one governing the ECRA. So it was a set of changes that were important, but were not in any predictable way going to advantage one party or another. On one hand, it was a response to 2020. And so I think there was always some chance or some risk that it might become politicized, might have been seen as uh, uh, um, polarizing depending on your view of the 2020 election.
Yeah.
But on the other hand, everyone involved in crafting the ECRA knew that the president of the Senate in the next election would be Vice President Harris. And so the partisan valence, the partisan dynamics sort of cut in both directions. I should say one thing about the ECRA, and maybe relevant to the politics here, is that the ECRA also makes clear that the role of the president of the Senate at the joint session is purely ministerial, that the president of the Senate
Oh, that's a big.
has no substantive role. I will say that I didn't lead with that because I think of that provision as codifying a constitutional understanding.
Yeah.
I think that that's true whether or not the ECRA says that it was true before the ECRA was enacted. That's a matter of how to interpret the 12th Amendment.
But it was a big issue on January 6, 2021, i.e., Mr. Pence, VP
it
Pence.
was a big issue, and
Yeah.
there were people arguing to Vice President Pence that he had unilateral authority available to him. He rejected that argument on the basis of the clear constitutional understanding. So, whether the ECRA did that, whether the ECRA removes any authority from the president of the Senate, I'm kind of skeptical. I don't think you need the ECRA to do that. But to your question, I do think that's probably relevant to the politics. It was probably relevant to an understanding that this is an important but technical set of changes that does not have any inherent partisan advantage one way or the other. And hey, by the way, in case you're worried that it's Democrats who who want to validate the 2020 election, and so they support the ECRA, this statute also makes clear that at the next joint session, when Vice President Harris is presiding, that her powers are purely ministerial.
You mean Democrats that would want to validate the 2024 election?
So let me put that differently. So one worry you might have had in passing the ECRA is that it would be seen as something that Democrats wanted to do because they wanted to validate the outcome in 2020.
I see.
Right? They wanted to reject the attack on the Capitol, right? They were aligned with the January 6th Commission. It's possible that the politics could have played out that way. I think it's appropriate that they didn't. And I guess I want to just suggest that maybe one element of the politics there is that the statute makes clear that the president of the Senate doesn't get any unilateral decision-making authority, even though the Democrats knew that the president of the Senate in the next joint session was going to be Vice President Harris.
I see. Professor Schwarzschild, I've monopolized your time for about an hour and 20 minutes now. I very much enjoyed it. At the closing, if you wanted our audience to remember just one point about our electoral college system, just one point after everything we've talked about, what would that one point be?
The thing I would say is to remember that the electoral college system was originally devised to solve a certain set of problems that were the pressing problems in 1787, 1788, right? Problems about how to ensure that each of the states had an appropriate role in choosing a president, problems about really worrying, would states have parochial interests or would they think about sort of national character? We've had to iterate then generation after generation in our legal frameworks and in our political understandings to make that framework fit with our current understandings of what presidential elections are meant to be, which is an opportunity for the voters across the country to participate and to ensure that the person who wins the popular vote in the right configuration of states, such that they earn an electoral count majority, should become the president. And because there's that delta And there's two things that might follow from that. One thing that might follow from that is the long-standing question of, do we still want an electoral college? Is that still the right framework? How do we think about alternatives?
Yeah, that's a big question. Yeah.
But putting aside that long-standing and probably long-term question, it also means through statutes like the ECRA, how do you build a framework that ensures that the system we have is going to accomplish what we think of as the modern political imperative? And so that means, right, when the people vote and those votes get translated into electoral votes from each state, do we have the right legal machinery to make sure that that's carried across the finish line, and that the person who becomes president is the person who won the most votes in the right configuration of states in order to prevail?
Yeah. Professor Schroestal, thank you so much for educating me and our audience. And to our audience, if you know of any history that could provide more perspective from the past on this subject, please share it with us and tell us what's your perspective. Thank you so very much.
Thanks so much. I enjoyed it.